Good morning, this is your Kelso Report for Friday, September 23rd, and I'm your host, Clark Kelso. Well, I think we know that the Internet has created a whole new set of intellectual property issues associated with the creation and use of domain names. Initially, self-regulation was the name of the game, and when it comes to domain names, the Internet Corporation for Assigned Names and Numbers, also known as ICANN, was the ultimate arbiter. But as with so many other public goods, self-regulation has not always been sufficient. So in the case of domain names, Congress enacted the Anti-Cyber-Squatting Consumer Protection Act, which prohibits cyber squatters from registering Internet domain names that are identical or confusingly similar to registered service marks and trademarks. The prohibition applies when a domain name is identical or confusingly similar to a mark that is distinctive at the time of registration of the domain name. Well, the issue before the Ninth Circuit in GoPets Limited versus Heiss was whether the word registration in the Act referred only to the initial registration of a domain name, or whether it also included the re-registration of a domain name. The original registrant for the domain name GoPets.com was one Edward Heiss, the defendant, who was the owner of a company known as Digital Overture, whose business is to register and maintain domain names for clients. Over the last decade, Heiss and Digital Overture have registered more than 1,300 domain names. In the case of GoPets.com, the site was supposed to be developed into a pet owner resource covering health, safety, nutrition, animal behavior, and so forth. Ultimately, very little was done to develop the site. Well, a few years later, after the registration initially, halfway around the globe, a game developer founded a company called GoPets Limited to market a game called GoPets, featuring virtual pets that move between the computers of registered users. GoPets Limited filed an application to register the service mark GoPets in the United States, which was duly registered. GoPets Limited made several attempts to purchase the GoPets.com domain name from Heiss, but those efforts led nowhere. After several years of fruitless attempts, the defendant sent GoPets Limited a letter indicating he would be willing to sell the domain name for $5 million. GoPets Limited had only a few months ago offered the princely sum of $40,000 for the domain name, so the parties were clearly not going to reach a deal voluntarily. At about this time, the defendant formally transferred the registration from himself to his corporation, Digital Overture, and then he re-registered the domain name. Well, not long after that, GoPets Limited filed an action in federal court, raising a claim under the Anti-Cyber-Squatting Consumer Protection Act and a claim under the Lanham Act for service mark infringement. The district court granted GoPets Limited's motion for summary judgment on both the anti-cyber-squatting claim and the Lanham Act claim, and awarded damages plus injunctive relief. The Ninth Circuit reversed in the anti-cyber-squatting claim. The district court found in favor of GoPets Limited because by the time the defendant transferred and re-registered the domain name, the name was at that time confusingly similar to the GoPets Limited service mark. The Ninth Circuit held as a matter of law that a registration under the Act referred only to the initial registration, and that re-registration of GoPets.com, in this case as a result of a transfer of ownership, did not violate the Anti-Cyber-Squatting Act. The defendant was not so lucky on the Lanham Act claim. There, the plaintiff's first commercial use of the service mark gave it priority, notwithstanding the defendant's prior registration, and the defendant's use of GoPets was properly found to be a violation of the Lanham Act. The Ninth Circuit remanded to the district court so that it could consider the appropriate scope of relief under the Lanham Act. So interestingly enough, the time-honored old Lanham Act cause of action proved to be a little more reliable than the new Anti-Cyber-Squatting Act enacted by Congress. Sometimes the old gets the job done when the new doesn't quite cover it. Well, our first one-liner is in the area of appellate jurisdiction in Prelwitz versus Sisto. The Ninth Circuit held that it lacked appellate jurisdiction where a district court had entered an order instructing the California Board of Parole Hearings to conduct a new parole hearing based apparently on the district court's assessment that the board had misapplied its some evidence standard of review. The board had actually held the new hearing before the Ninth Circuit heard the appeal from the district court's order, so one of the Ninth Circuit judges found that the jurisdiction was lacking simply because the appeal was moot. The concurring opinion did express some concern that the majority's rule might insulate from appellate review all district court decisions that had erroneously granted new parole hearings based on the district court's review of the merits of the board's decision. A merits-based review that the Supreme Court held earlier this year in Swarthout v. Cook was plainly erroneous. Well, if that concern turns out to be true, don't be too surprised if the state doesn't take one of those jurisdictional cases back up to the Supreme Court for review. Our next case involves appropriations in the state budget. In Tomar Pacific v. Chung, the First District held the legality of loans, or the First District upheld the legality of loans from a number of state special funds to the state general fund to help balance the budget during this period of fiscal crisis. For example, the state legislature authorized borrowing from the recycling fund, which receives recycling fees from beverage distributors, in the amount of $188 million for fiscal year 2002 and 3. The court rejected a challenge based on the single subject rule, concluding that the subject of the budget bill was appropriations and budget, and the loan provisions dealt with appropriations. And court rejected arguments that the loan violated the organic statutes for the affected agencies or programs. So really the only way to protect special funds from this type of borrowing is to enact a constitutional protection, which none of the funds involved in this case could claim to have. Next, an interesting problem involving sexual violent predator evaluations in People v. O'Connor. The Second District held that a staff shortage associated with the state's budget crisis was not an exigent circumstance under Section 6601.3 of the Welfare and Institutions Code, justifying a 45-day extension of an inmate's sentence for purposes of completing an evaluation of whether the inmate was a sexually violent predator. Now, ordinarily, absent such an exigent circumstance, the prosecutor's petition to commit the inmate as a sexually violent predator should have been granted. However, the Second District held that because there had not previously been a judicial construction of exigent circumstances in this context, the unlawful 45-day hold in this case was the result of a good faith mistake of law under Section 6601, and therefore the petition for commitment should not have been dismissed. So the court essentially saves the petition for commitment in this one case from dismissal, but for the future, it is now clear that staff shortages do not justify extending an inmate's sentence by 45 days for an SVP evaluation. Finally, an interesting case involving an attempt to form a special assessment district. In Golden Hill Neighborhood Association versus City of San Diego, the Fourth District held that the formation of the Greater Golden Hill Maintenance Assessment District was unlawful under the provisions of Proposition 218 and Article 13D of the California Constitution. The district was formed to collect assessments to pay a prescribed portion of the costs of future improvements, maintenance, and services for such things as debris and litter removal, enhanced litter containers, sidewalk sweeping, sidewalk washing, trash removal, and so on. Proposition 218 requires that the voting on a proposed special assessment be weighted according to the proportional financial obligation and benefits of the affected properties. An engineer's report explained how those proportional benefits and obligations were calculated and applied the same methodology to all properties in the district except for public parks or designated open space areas. For public parks and designated open space areas, the report simply listed the assessment amounts, but did not indicate at all how those amounts were determined. According to the court, the failure to disclose that methodology, quote, compromised the transparency and integrity of the election process by depriving other property owners in the district the opportunity to review and challenge the vote weighting for those properties, close quote. The issue was important because if those properties were more heavily weighted than they should have been, which was the allegation, it would have had the effect of giving the city, which favored formation of the proposed district, disproportionate weighting in the voting. So, as a result of the failure to disclose the methodology, the 4th District held the formation of the district was unlawful, and the court invalidated the assessments which had been imposed by the district. Well, that's it for the Kelso Report today. Have a great day in the law.